Welcome to 5-Star Senior Living's HIPAA Training. I'm Tina Sheldon, 5-Star's Chief Compliance Officer and Associate General Counsel. Today, I'm going to take you through the nuts and bolts of HIPAA. Specifically, I'm going to go over the HIPAA basics, what it is, who it applies to, and how it applies, the HIPAA rules, essentially the do's and don'ts of HIPAA, HIPAA and you, how it applies to you and your job and what your role is, and lastly, HIPAA in real life. We're going to apply the rules looking at your role and 6 real-life situations. So let's begin. What is HIPAA? 1, it's an acronym, and it stands for the Health Insurance Portability and Accountability Act. Now that's a mouthful, so you can see why it's called HIPAA. Secondly, it's a federal privacy and security law. And third, its primary purpose is to protect and secure health information. Now some of you may be thinking, privacy of health information is not new. And you're right, it's not new. For decades, healthcare professionals have treated health information confidentially. But as information technology has developed, security of that information has gotten more challenging. So HIPAA's goal is to safeguard health information and, at the same time, allow for information to flow as needed to promote high-quality health care. As a side note, there are consequences for non-compliance with HIPAA, which is in essence breaking the law. There are both civil and criminal penalties that may be imposed both on 5-Star and you. Also, if you're a licensed professional, such as a registered nurse, you could potentially lose your license under your state's Nurse Practice Act. Bottom line, this training is very important. So who must comply with HIPAA? Well, HIPAA applies to 3 groups. The first are health plans or healthcare insurers, such as Medicare, Medicaid, and private health insurance companies. The second are healthcare clearinghouses, for example, a third-party billing company. And lastly, and probably most importantly for our purposes, healthcare providers. This group includes all healthcare providers who provide medical or health services and electronically submit claims to third-party payers, for example, physicians, hospitals, and skilled nursing facilities. In HIPAA speak, these 3 groups are commonly referred to as covered entities, meaning they're covered by the law and they must comply with the law. What must a covered entity protect? Well, covered entities must protect information that is individually identifiable. This may include demographic data that relates to the provision of health care to an individual. The protection includes physical and mental health conditions and includes past, present, and future conditions. In addition, it applies to oral, paper, and electronic information. Collectively, this individually identifiable information is considered protected health information, or in HIPAA speak, it's referred to as PHI. It's important to note that the information must be related to the provision of healthcare services. For example, if a coworker told you she was recently diagnosed with high blood pressure, that is not protected health information or PHI. However, if during a healthcare assessment, a resident told you as a 5-Star employee that she was recently diagnosed with high blood pressure, that is considered protected health information or PHI. The difference is the context in which the information is being shared. In the first scenario, information was shared from one colleague to another colleague, and in the second scenario, information was shared from a resident to a healthcare professional. This slide shows examples of identifiers of protected health information, or PHI. The center circle includes past, present, or future physical or mental health conditions. This may include anything from a medical diagnosis, lab results, X-ray, prescription medication, to a medical invoice. The overlapping outer circles are examples of identifiers. In other words, if any one of the outer circle identifiers is combined with the center circle, it is considered protected health information, or PHI. For example, if my name is included with my health condition, such as my diagnosis, it is protected health information. Now, I'm not going to go through all of the identifiers, but I would like to highlight a few. One is name. Name may include first name, last name, or first and last initials. All are considered identifiers. The second identifier I'd like to highlight is street address. This may include the street number, the street name, the city, state, or even zip code. All are considered identifiers. Now, this is a lot of information to take in. The key takeaway is that it doesn't take much to make the information identifiable, as we just saw with someone's name or street address. Remember, if any one of the outer circles are combined with a physical or mental health condition, it is always considered protected health information, or PHI. So how does this apply to 5-star? Well, let's look at the corporate structure. 5-star is a senior living company with a continuum of communities and services ranging from independent living to skilled nursing. Some settings look more like apartments, such as IL, and others more like healthcare facilities or services, such as skilled nursing facilities, rehab and wellness, and home health. All along this continuum, 5-star respects the privacy of its residents, and consequently, 5-star treats all of its communities and services as if each is a healthcare provider. In other words, 5-star is a covered entity, and HIPAA applies to all of 5-star's communities. You may be wondering, how does this apply to IL communities? Well, generally, ILs do not have PHI. However, if the IL is part of a continuum care retirement community, or has an outpatient rehab clinic, or has a wellness center, the community may have PHI on site. Even if a community does not regularly use or store PHI, we must always protect our residents' privacy. From time to time, 5-star engages vendors or contractors to assist the community. If those vendors or contractors have access to, use, or disclose PHI on our behalf, they are considered business associates and will need a special contract called a business associate agreement. This training will not go into any detail on business associates. However, if your community has a vendor that has access to, uses, or discloses PHI on 5-star's behalf, please contact the legal department. We will address any questions or concerns you may have regarding business associate agreements. So let's recap. 5-star is a covered entity. So no matter what type of community or service, whether it's independent living, assisted living, skilled nursing facility, continuing care retirement community, home health agency, or rehab and wellness, HIPAA always applies. Remember, when you combine a 5-star community with a 5-star resident with individually identifiable information, it will always equal protected health information. And remember, HIPAA is a privacy law that protects the health information. So how does this fit in with 5-star's values? Well, first and foremost, 5-star puts people first, meaning we respect our residents, and HIPAA puts patients' privacy first. As a footnote, given 5-star's many settings, we may refer to individuals by different names, such as patient, resident, client, or customer. These references are interchangeable and are often used to describe the same person, namely the individual whose PHI is to be protected. For ease of reference in this training, individuals will be called resident. Whether someone lives in an IL, AL, or SNF, or seeks therapy at a R&W clinic, we will refer to individuals as residents. So to recap, we've just gone over the basics of HIPAA. What it is, it's a federal privacy law, to whom it applies, healthcare providers, and how it applies to 5-star, all of our communities and services. Now we'll turn to the HIPAA rules. These are essentially the do's and don'ts of HIPAA. The rules are simple. There's one gold standard and 3 rules. How easy is that? First and foremost, there's the gold standard. Whenever you use or disclose protected health information or PHI, you must always use or disclose what's minimally necessary. In addition to the gold standard, there are 3 rules of the road. 1 is permitted uses and disclosures, 2 is restricted uses and disclosures, and 3 are prohibited uses and disclosures. Before we discuss each rule in greater detail, let's take a look at how they all fit together. I like to refer to this flowchart as the HIPAA traffic light. It provides the big picture, and for those of you to whom a picture's worth 1,000 words, this one's for you. Throughout the training, we'll be coming back to this traffic light, especially when we talk about HIPAA in real life. As you can see, whenever you use or disclose PHI, the gold standard or minimum necessary standard will apply. It limits use and disclosure. Rule 1, permitted use and disclosure, is green, and like a traffic light, green signals go. Rule 2, restricted use and disclosure, is yellow, and like a traffic light, yellow means proceed with caution. Lastly, Rule 3, prohibited use and disclosure, is red, and like a traffic light, it signals stop. So let's look at each of these rules a little more closely. First, the gold standard, minimum necessary information. The key to remember is it's a general rule and it always applies. It's a simple rule, and it's meant to limit access, use, and disclosure to only that which is necessary to perform your job. In other words, it's on a need-to-know basis. For example, if an insurer, such as Medicare, requested records regarding a specific service, such as therapy, the insurer does not necessarily need the entire medical record. They may only need the therapy section. Now let's take a look at the 3 rules. The first rule is permitted uses and disclosures. Remember, it's green because they're permissible uses and disclosures under HIPAA. There are 5 circumstances in which Rule 1 applies. The first is to the individual. Second is to include in the community directory. Third is to family members involved in the individual's care. 4 is for treatment, payment, or healthcare operations, which is referred to as TPO. And 5 is for public interest and public benefit activities. Let's take a look at each of these situations. The first permitted use and disclosure is to the individual. Sometimes we forget this most basic use and disclosure. Individuals have a right to their health information. In fact, the resident owns the record. 5-star is merely the keeper, or what's often called the custodian of the record. As such, you may disclose PHI to the individual and/or their personal representative, such as a healthcare power of attorney. The second permitted use and disclosure is for community directory. For those communities that have a community directory, the community is permitted to use the following information in their directory, unless a resident has advised them otherwise. 1 is the resident's name. 2 is the resident's general condition, such as good or fair. 3 is the resident's religious affiliation. And 4 is the location within the community. But please note that a resident always has a right to restrict the information in a community directory. We'll discuss resident rights a little later on. But for now, know that if a resident does not want to be listed, you must respect their request. The third permitted use and disclosure is to family members and close friends involved in the individual's care. Communities are allowed to share information that is relevant to their residents' care with the residents' family members and close friends if the family members and close friends are involved in the residents' care. But remember, the minimum necessary or gold standard always applies, so you should only share information that is relevant. In addition, please note that like we just saw with community directory, the resident has the right to object to sharing information with his or her family members. Therefore, if a resident says that he or she does not want his or her family or close friends to receive information about their condition, you must respect their request and not share the information. The fourth permitted use and disclosure is for treatment, payment, or healthcare operations. This is the largest permitted use and disclosure, and it's commonly referred to as TPO. Treatment permits use and disclosure for the provision, coordination, and management of healthcare-related services for an individual. It also permits use and disclosure by one or more healthcare providers. It also permits consultation between providers regarding a resident and for referral of a resident from one provider to another. All of these uses and disclosures allow for the exchange of information to promote quality of care. The second area is payment, which permits use and disclosure for submitting claims, making coverage decisions, for claims processing. All of these uses and disclosures permit for the exchange of information to provide reimbursement. The last area, healthcare operations, permits use and disclosure for quality improvement and assessment activities, for administrative support, for data collection, and for training and auditing functions. All of these uses and disclosures permit flow of information to operate the community. Remember, these are all green because they're all permitted uses and disclosures, and they all allow for continuity and quality of care. Even though they're permitted uses and disclosures, remember, the gold standard of minimum necessary information will always apply. This slide provides examples of treatment, payment, and healthcare operations. Notice the outer circles are all connected, permitting the flow of information and to further the quality and delivery of care. Now, I'm not going to go through each of the examples, but I do want to highlight a few. The first are medical office visits or wellness centers. For example, if your community has a podiatrist come in once a month, that is an example of treatment. Second, physical therapy. Some communities have rehab and wellness outpatient clinics, or skilled nursing facilities have inpatient therapy services. Another area are incident reports. For example, if a resident slipped and fell, a report would be written and sent to MedTech. Remember, these uses and disclosures are green because they're permitted. The fifth permitted use and disclosure is for public interest or public benefit activities. Now, this is truly a balancing act between individual privacy and the public interest. Remember, even though they're permitted uses and disclosures, the gold standard or minimum necessary information will always apply. So let's look at the balance. On the left-hand side of the screen is an individual's privacy and their protected health information, which is weighed against the public interest and public benefit activities on the right-hand side of the slide. This is more for illustrative purposes and is not meant to represent all of the types of public interest or public benefit activities. There is a range from those that are required by law to those that are public health activities to abuse and neglect reporting. This slide may be a little overwhelming, and although we will not be going into each of these activities, know that resources are available. You're not alone in navigating this area. Let's look at some examples which may make more sense. On this slide, we have some situations that you may encounter. For example, a state agency such as the Department of Public Health or a state surveyor may visit your community and request information. The visit may be announced or unannounced. Another example is a Medicare auditor who may also request records. This may be a fiscal intermediary or a contract auditor. Another example is elder abuse reporting. 5 Stars, a senior living company, is a mandated reporter. The state agency overseeing the report may request further documents or want to interview staff. Another example may be a subpoena, a police, or government agency. Any requests for protected health information by these individuals or state or federal agencies must be reviewed by the local privacy officer, who is your community's executive director, and it must be reviewed in conjunction with me as the Chief Privacy Officer, as well as the legal department at corporate. Now let's turn to the second rule, which is restricted uses and disclosures. There are three common circumstances in which Rule 2 applies. The first is any use or disclosure of psychotherapy notes, because this information is highly sensitive. The second area are marketing activities, and the third are fundraising activities. Please note that marketing and fundraising are not healthcare related activities, and so these require greater scrutiny. We'll discuss additional Rule 2 circumstances on the next slide. But remember, Rule 2 is the yellow zone, meaning you must proceed with caution, and like a traffic light, you'll need to slow down. In order to use or disclose this type of information, you'll need to get an authorization from the resident. On this slide, we have some situations you may encounter. 5-Star must obtain a signed authorization from the resident prior to using, accessing, or disclosing PHI for any reason other than those listed in Rule 1. The following are common examples or circumstances which require an authorization. Now, I won't go through each of them, but I would like to highlight a few. 1 are photos on community Facebook pages. 2, I'd like to highlight local news story if the media comes to the community. And 3, requests from records from a law firm when it is not accompanied by a subpoena. Remember, this is the yellow zone, so before proceeding, you must obtain a proper authorization from the resident prior to using or disclosing their PHI. If the information is not to the individual, for the community directory, for treatment payment healthcare operations, or for the public benefit, then an authorization will be required. If you think you need an authorization, please consult your local privacy officer or your executive director or administrator. 5-Star specific authorization forms that need to be completed prior to each use. Well, let's recap. If the use or disclosure involves psychotherapy notes, marketing or fundraising activities, or any of the examples just discussed, a proper authorization must be obtained to ensure proper use and disclosure. Remember, with a proper authorization, yellow becomes green and caution becomes go. Now let's look at the final rule. Rule 3 is prohibited uses and disclosures. It's red because they're not permitted under HIPAA and 5-Star's policies. Like a traffic light, red means stop. Please note that these are really not new rules. Rule 3 complements 5-Star's rules of conduct, which is outlined in the employee handbook. In a nutshell, never use personal cameras or recording devices at work to take a photo or video of a resident. Never use personal computers or mobile devices, such as a smartphone or tablet, to use or access resident information. And never post anything related to 5-Star and its residents on social media. Please note the context. Rule 3 applies to personal use and disclosure. Remember, keep personal and business separate. Use of personal cameras, recording devices, personal computers, or other personal devices to record, access, or disclose any information about our residents is strictly prohibited under 5-Star's policies. To recap, use of personal electronic devices to access information involving 5-Star residents is always prohibited. Let's revisit our HIPAA traffic light. This flowchart will be key as we look at HIPAA in practice. First, you need to ask yourself, is it PHI? If yes, then the gold standard of minimum necessary information will always apply. Then you need to ask yourself, is it a permitted use or disclosure? Is it to the individual, for the community directory, to family members involved in care, for treatment payment healthcare operations, or for the public interest or benefit? If it's not one of these, you need to ask yourself if it's a restricted use or disclosure requiring a prior authorization. For example, does it involve psychotherapy notes, or is it for marketing, fundraising, or any of the other uses that is not automatically permitted? And if it's none of the above, then it is prohibited. Remember, when in doubt, don't give it out. You're not alone in this. Now we'll discuss resources in a bit. To recap, we've gone over the HIPAA basics, what it is and who it applies to. We've just gone over the HIPAA rules, the do's and don'ts or rules of the road. Now we're going to discuss HIPAA and you. We're going to look at your role and remember the STAR principle of stop, think, and act responsibly. So what's your role? No matter what your job is, we all play an important role in protecting our residents' privacy. There are 5 things we must all do. 1. Take the HIPAA training, which you're doing right now. 2. Know the HIPAA rules, which we've just gone over. There's 1 gold standard and 3 rules. 3. Respect our residents' privacy rights, which we'll review. 4. Ensure that you safeguard our residents' PHI, which we'll discuss. And 5. Report any improper uses and disclosures, which we'll also discuss a little later. Looking at your obligations, let's start with respecting residents' privacy rights. HIPAA gives residents several rights, including receiving a notice of privacy practices. This is actually part of their admission packet and is posted in your community. They also have a right to receive their medical records, and this is consistent with Rule 1, Permitted Use and Disclosure. Remember, the medical record belongs to the resident, and they have a right to receive a copy of it. They also have a right to restrict uses and disclosures. Again, this is consistent with Rule 1, Permitted Use and Disclosure. Remember, the resident can restrict information in the community directory and can restrict information provided to family members involved in their care. They also have a right to request to amend their medical records. Continuing on, residents have a right to request confidential information. For example, they may request only to receive oral communications or conversely, only written communications. They have a right to request an accounting of disclosures. And lastly, residents have a right to file a complaint to 5-Star and/or the Office of Civil Rights. If you are unsure, always ask your supervisor or executive director or administrator. Now we're going to focus on your role, which is to safeguard protected health information. Now, this may seem like common sense, and it's very important in ensuring our residents' privacy and security of protected health information. Remember, we all play a role in safeguarding information. It doesn't matter whether you're a direct caregiver or work in dining services, for example. Our number 1 value is to put people first, and safeguarding their health information is part of that. Safeguarding information is not new. It's also consistent with our policies in the Employee Handbook and ties back to the STAR principle. There are 3 types of safeguards we'll discuss: administrative, physical, and technical. Administrative safeguards are internal controls put in place by 5-Star. They set a framework and are a foundation to protect PHI. Understand, participate, and report. Understand 5-Star's privacy policies. We have developed a manual that has simplified the prior policies and is consistent with the gold standard and 3 HIPAA rules we just discussed. Secondly, participate in 5-Star's privacy training, which you are. And third, report any potential privacy breaches, which we'll go over in a few minutes. Physical safeguards are in place to ensure privacy of our residents' PHI. They're verify, secure, and ensure. Verify others' access to PHI. For example, if you're talking to someone on the telephone, confirm to whom you're speaking and the entity or organization from which they're calling. And do not leave PHI on a voicemail. Secondly, secure your workstation. For example, do not leave PHI out in a cubicle or visible to others, such as on a countertop, in the dining room, in the activities room, or on your computer screen. And third, ensure proper disposal of PHI. For example, do not leave PHI in the trash or recycle bin. Dispose of it in a shredder or locked box for shredding. And never take PHI home with you. Lastly, There are electronic and technical safeguards. They are secure and ensure. Secure access to PHI. Even though we do not yet have electronic health records, there is PHI on our computers. For example, there may be billing information. When we have electronic PHI, we need to secure access to it. This can be as simple as protecting your logon password. For example, do not give your password to others, lock your computer or log off when you leave your workstation, and do not leave your password on a sticky note on your desktop. Secondly, ensure safe transmittal of PHI. Do not save PHI on a flash drive or CD. If you need to electronically send PHI, you must do so through encrypted email. We are in the process of rolling out this new application. If you do not have email encryption software, please consult your supervisor in IT. If you're not eligible for encrypted software, please send PHI via fax with delivery confirmation or send next day FedEx with delivery confirmation. And never send PHI via text. It is always unsecure. Throughout the training, I've told you that you are not alone. Thus far, we've covered a lot of ground, but help is available. Remember, compliance starts with you. First, review the HIPAA checklist and the stoplight guide. Is it PHI? Is it permitted? Is it restricted? Or is it prohibited? Second, if you're unsure of what to do and you still need help, start with your supervisor, then your local privacy officer, which is your executive director or administrator, and lastly me. Follow the chain of command. We're here to support you. These are your go-to personnel. Third, if you need to report a potential HIPAA issue, follow the chain of command. Go first to your direct supervisor, then to your local compliance and privacy officer, and lastly me. In addition to your go-to personnel, we've got a number of tools to help you. First, visit the new compliance website. It's your resource center to being HIPAA compliant. Resources include a new and improved privacy manual that's hyperlinked and easy to navigate. It also includes decision trees to help you figure out next steps. And it includes real-life, frequently asked questions from your colleagues in the field. Second, call the HIPAA hotline. It's available for any questions or concerns you may have about improper use or disclosure of our residents' PHI. In addition, there's a new HIPAA privacy manual that sets forth policies and procedures, a glossary of HIPAA terms, an index of state privacy laws, which are encompassed in our general policies. Note, most states have privacy laws regarding personally identifiable information. These laws are much like HIPAA. We've incorporated their general principles in this manual, but please note some states are more restrictive than HIPAA. The manual also includes an index of privacy forms and a frequently asked questions section. Thus far, we've gone over the HIPAA basics, the HIPAA rules, and HIPAA and you. Now we're going to put it all together by looking at some real-life examples and testing your HIPAA knowledge. The following slides are 6 real-life examples, and we're going to approach each example in the following ways. We're going to review the facts, pose 3 questions, analyze the scenario using the HIPAA traffic light, determine which rule applies, review the STAR principle, and review our HIPAA tools and resources available. So let's begin. Example 1. A physical therapy assistant uses her phone's camera to take a picture of herself with a resident. Does HIPAA apply? If yes, what rule? And what's your role? Now, some of you might describe this photo as cute or sweet, but before we answer the questions, let's go through the HIPAA rules and your role. Looking at the facts, is a personal selfie with a resident PHI? The answer is yes, because if we go back to the HIPAA basics, the photo personally identifies the resident resides in a 5-star community, and the community is a covered entity under HIPAA. Remember, it doesn't matter what type of community, all of 5 stars a covered entity. As such, the selfie would be considered PHI. Let's move down to step 2. Is it a permitted use of PHI? The answer is no, because it's not being used or disclosed to the individual, to his or her family, for their care. It's not in the community directory. It's not for treatment, payment, healthcare operations, and it's not for public benefit activities or public interest. So that takes us to step 3. Is it a restricted use or disclosure requiring a prior authorization form? The answer is no, because it's not being used or disclosed of psychotherapy notes, nor is it being used for marketing or fundraising activities. That takes us to step 4, and it's prohibited. Not only is it prohibited under HIPAA, but use of a personal camera to take a picture of a resident is strictly prohibited by 5 Stars policies. So let's turn to your role. Your role is to stop, think, and act responsibly. And your role is to safeguard our residents' privacy. Remember, we put residents first and HIPAA puts privacy first. We do not permit use of personal cameras to photograph residents. So, looking at example 1, does HIPAA apply? The answer is yes. What rule? It's Rule 3, it's prohibited, and we're in the red zone. What's your role? Your role is to safeguard the information. Remember, use of personal cameras or recording devices with 5-star residents is in the red zone. And 5 Stars use of cameras and recording devices policy applies to all communities, including IL. Let's look at example 2. Here, a resident at an AL community is turning 100. The AL staff wants to take her picture and post it in the activities room. The resident signs an authorization by resident for use of camera and recording device form, and the staff uses the community's camera to take the photo. Does HIPAA apply? If yes, what rule? And what's your role? Here's another photo, but a different set of facts. As we go through the analysis, you'll see that the facts make a difference. So let's review the facts. Is a photograph of a resident participating in a community activity PHI? The answer is yes, because if we go back to the HIPAA basics, the photo personally identifies the resident resides in a 5-star community, and the community is a covered entity under HIPAA. Therefore, the photograph would be considered PHI. Let's move down to step 2. Is it a permitted use of PHI? The answer is no, because it's not being used or disclosed to the individual, to his or her family member for their care. It's not in the community directory. It's not for treatment, payment, or healthcare operations. And it's not for a public benefit activity or public interest. That takes us to step 3. Is it a restricted use or disclosure requiring a prior authorization form? The answer is yes, because it's being used for a community function that is not automatically permitted. Because the photo is not being used for an automatically permitted reason, we're in the yellow zone. Remember, yellow becomes green with a proper authorization form. So let's turn to the right-hand slide. What's your role? Remember, it's to stop, think, and act responsibly, and it's to safeguard our residents' privacy. Remember, we put residents first and HIPAA puts privacy first. While we do not permit use of cameras as demonstrated in the prior example, we do permit use of 5-star cameras for resident photos. However, to properly safeguard our residents' identifiable information, including photos, we need to obtain a prior authorization. So let's review example 2. Does HIPAA apply? The answer is yes. What rule? It's Rule 2. It's a restricted use and disclosure. What's your role? To safeguard information. Unlike example 1, this is a restricted use of PHI requiring a resident authorization form prior to photographing the resident. And unlike example 1, the camera is a 5-star camera and is being used with an authorization for community function. Remember, this rule applies to IL and AL because all of 5 stars considered a covered entity. Let's turn to example 3. In this example, a 5-star community emails a list of residents' current medications to a physician outside of 5-star network. Does HIPAA apply? If yes, what rule? And what's your role? Well, let's go through the analysis. Let's look at the facts. Is an email of a resident's medication list to a physician PHI? The answer is yes, because if we go back to the HIPAA basics, the email contains personally identifiable health information, a medication list. The resident lives in a 5-star community, and 5-star is a covered entity under HIPAA. Therefore, the email would be considered PHI. So let's move down to step 2. Is it a permitted disclosure of PHI? The answer is no, but this is a tricky one. Sending an email from 5-star, a covered entity, to a physician, a covered entity, is a provider-to-provider communication. The disclosure is for treatment purposes, and normally this would be a permitted use under Rule 1. However, PHI may not be sent via email unless it is being sent from one 5-star email address to another 5-star email address. Here, the PHI is not being sent securely, so the disclosure is not permitted. So let's turn to the right-hand side of the screen. What's your role? Your role is to stop, think, and act responsibly in safeguarding our residents' privacy. Remember, we put residents first and HIPAA puts privacy first. First, the gold standard applies. Only supply minimally necessary information. 2. Safeguard access to the information by verifying the treating physician. And 3. Safeguard the disclosure. If you have encrypted email, you may transmit the medication list via the secure application. If you do not have encrypted email, you can fax the medication list with delivery confirmation after verifying the fax number. So, does HIPAA apply? The answer is yes. What rule? Rule 1. It's permitted, but only if the appropriate safeguards are undertaken. And what's your role? To safeguard the information. Protected health information may be sent via email if it is being sent from one 5-star address to another 5-star address. However, if it goes outside a 5-star email address, it must be encrypted. Safeguarding outside 5-star does include encryption. Example 4. In this example, a skilled nursing facility resident is admitted to the local hospital. A nurse at the hospital calls the skilled nursing facility and asks for a list of the resident's current medications and treatments. A 5-star nurse gives her this information over the phone. Does HIPAA apply? If yes, what rule? And what's your role? Well, let's look at the analysis. So let's look at the facts. Is an oral disclosure to a hospital of a resident's medication list PHI? The answer is yes, because if we go back to the HIPAA basics, the medical list personally identifies the resident resides in a 5-star community, and the community is a covered entity under HIPAA. Therefore, the medication list would be considered PHI. So let's move down to step 2. Is it a permitted use of PHI? The answer is yes, because oral communication from one 5-star community to a hospital is a provider-to-provider communication, which is a permitted disclosure for treatment purposes. So let's turn to your role. As always, your role is to stop, think, and act responsibly in safeguarding our residents' privacy. Remember, we put residents first, and HIPAA puts privacy first. First, apply the gold standard. Only supply what is minimally necessary. 2. Safeguard access to the information by verifying the treating hospital. So, in summary, does HIPAA apply? The answer is yes. What rule? It's Rule 1. It's a permitted use and disclosure. What's your role? To safeguard the information. Remember, HIPAA applies to oral communications. So let's turn to example 5. Here, a CNA prints out the resident roster and notes each resident's vital signs on the roster. Later, she enters the information into the resident's chart and shreds the printed roster. Does HIPAA apply? If yes, what rule? And what's your role? Well, let's review the facts. Is the printout of a resident's name and vital signs PHI? The answer is yes, because if we go back to the HIPAA basics, the resident's vital signs personally identify the resident resides in a 5-star community, and the community is a covered entity under HIPAA. Therefore, the printout of the resident's vital signs would be considered PHI. That takes us to step 2. Is it a permitted use of PHI? The answer is yes, because the CNA is accessing and using the PHI for treatment purposes by recording the information into the resident's chart. So let's turn to the right-hand side. What's your role? Your role is to stop, think, and act responsibly in safeguarding our residents' privacy. Remember, we put residents first and HIPAA puts privacy first. First, we'd apply the gold standard. Only supply what is minimally necessary. Second, safeguard disposal of the PHI. The CNA could either shred the paper document or put it into a secure disposal bin. To recap, does HIPAA apply? The answer is yes. What rule? Rule 1, it's permitted. What's your role? To safeguard the information. Ensure proper disposal of the paper records of PHI. Again, let's look at example 3. A nurse writes her resident's first name and their medications in a notebook that she takes home with her. Does HIPAA apply? If yes, what rule? And what's your role? Well, let's start with step 1 and review the facts. Is a notebook containing a resident's name and medication PHI? The answer is yes, because if we go back to the HIPAA basics, the notebook identifies the resident resides in a 5-star community, and the community is a covered entity under HIPAA. Therefore, the information in the notebook would be considered PHI. So then let's move down to step 2. Is it a permitted use of PHI? The answer is no, because it is not being used or disclosed to the individual, to his or her family and their care, in the community directory, for treatment, payment, or healthcare operations, or for public benefit activities or public interest. That takes us to step 3. Is it a restricted use or disclosure requiring a prior authorization form? The answer is no, because it's not a use or disclosure of psychotherapy notes, nor is it for marketing or fundraising or any other restricted use activity. That takes us to step 4, and in the red zone, and it's prohibited. So let's look at what your role is. Your role, as always, is to stop, think, and act responsibly in safeguarding our residents' privacy. Remember, we put residents first, and HIPAA puts residents' privacy first. We do not permit any employee to take PHI home. So let's recap. Does HIPAA apply? The answer is yes. What rule? It's Rule 3, it's prohibited. And what's your role? To protect our residents' health information. We have an obligation to safeguard their information. And remember, what happens at work stays at work. So today we've gone over a lot. We've gone over the HIPAA basics. We've gone over the HIPAA rules. There's 1 gold standard and 3 rules. We've discussed HIPAA and you. And lastly, we've talked about HIPAA in real life. We've covered a lot of material. But remember, you're not alone. You've always got your 5-star HIPAA toolbox, which has your HIPAA manual, your HIPAA hotline, and HIPAA website. And you've always got your 5-star go-to personnel. You've got your direct supervisor, the local compliance and privacy officer, which is your executive director or administrative director, and me, the chief compliance officer. Finally, congratulations. You've just completed 5 Stars HIPAA training. Please sign the Acknowledge form and submit it to your local HR. I also wanted to provide for you my direct contact information should you have any questions or concerns. Remember, you've always got your supervisor, then your local privacy officer or executive director and administrator, then me. But remember, compliance starts with you. So stop,